Constitutional Court has dismissed an application by the Electoral Commission of South Africa to postpone the 27th of October municipal elections. The Apex Court today ruled that elections have to take place between the 27th of October and the 1st of November 2021. Now, to talk about what this means as a way forward, I'm joined by Tselane, who's the chairperson of the Institute of Election Management Services. Good evening to you, Tselane. Thank you so much for your time this evening. Some are saying that they are concerned about the free and fairness of the elections, especially when you look at a ruling like this one. How then are they, will you, as you are looking on at this particular process, how can the free and fairness of the elections be determined when it comes to at the back of this ruling?
Well, the Constitutional Court has already ruled that in order for us to be able to make a determination on whether the elections are free and fair, we've got to look at the context. And the context that Justice Moseneke raised in his report when he was doing this inquiry was the context of COVID-19. But unfortunately, COVID-19, it's a moving target in the sense that at the time when the inquiry was held, there was an understanding that there was a possibility that by February, the country would have achieved community immunity. However, what the inquiry had not taken into consideration at that time was the fact that there was going to be this hesitancy that we have in relation to COVID vaccinations. Now, that on itself is an important aspect in ensuring free and fair elections, and therefore, I always understood that the Constitutional Court was most likely going to say that the elections should proceed as determined by the Minister of Cooperative Governance, which is the 27th of October. But the most important aspect of what the Constitutional Court has done is that it has now allowed for the IEC to register new voters, which was a plea from the Democratic Alliance. So now the Electoral Commission has got to allow for new registration as per the Constitutional Court judgment, and make sure that the elections still take place within a constitutionally stipulated period. So the Minister, as a proclamation of the date of the elections, has also been nullified. But at the same time, the Minister has been given an opportunity to redetermine the date of the elections within a constitutional stipulated period.
The Constitutional Court says the election timetable adopted on the 4th of September remains in place and cannot, ineffective, I understand this, that it says that it cannot be revisited. What does it mean then for those that were decrying some system glitches and wanting then to field some candidates and then work on their lists, going forward?
Well, when the Constitutional Court says that the election timetable cannot be changed, it basically means that the arrangement as is will proceed accordingly. What I am not sure about is the fact that the Minister has made a determination, and that determination has been nullified, which means that that determination, which is in terms of Section 24 of the Structures Act, where the Minister determines the date of the elections, its implications for overall processes, particularly in terms of the election timetable. So it's going to be very interesting how the process unfolds in the light of the fact that the Constitutional Court says the election timetable remains, but at the same time nullifies the Minister's proclamation of in terms of Section 24 of the Municipal Electoral Act. How one then begins to maneuver within this is going to be absolutely interesting.
How important was the prayer then that the Constitutional Court did not want the Constitution changed?
It's a very important thing because, from the beginning, some of us have indicated that what the Electoral Commission is supposed to have done following the submission of the report by Justice Moseneke following the inquiry was to go to Parliament, because Parliament was the only structure that was empowered to amend the Constitution in terms of Section 159, which basically says that the term of office of a municipality is 5 years. So when the Electoral Commission did not approach the Parliament as the structure that was empowered to deal with this aspect, it was always going to be a difficult aspect for the court to deal with a section basically where they are not empowered to deal with. Because the role of the Constitutional Court, like all other courts, is to interpret the legislation and the application thereof, and not to amend the Constitution. So only Parliament had the powers to do so, and the Commission is supposed to have gone to Parliament to ensure the amendment of Section 159 of the Constitution so that it extends the term of office of a municipal council.
Dr. Tselane, there's some varying opinions here. Some are saying that the fact that it cannot be revisited means that it's closed and that's it. But others are saying that there might be a loophole here that may lead to the reopening then of some of the councillors, like the PR councillors, to be able to take part. Is that your understanding as well?
Absolutely. I mean, once you open for registration of voters, it means some of the voters who were disqualified on the basis that they were candidates but they had not registered would be now allowed to register and to be on the voters' roll. Now, I don't see how, on the basis of that, you can now disqualify them on the basis of the fact that now they've registered or, now they're on the voters' roll. And even though the deadline had passed, how you would now disqualify those people in terms of participation as candidates for the election. So it's going to be very interesting how this issue is dealt with now that the Constitutional Court says registration of voters can happen, because the registration of voters has got implications for candidate list and then those people who should actually be considered as candidates for the purpose of these elections.
Dr. Tselane, thank you so much for your time this evening. We certainly do appreciate it. That was Tselane of the Institute of Election Management Services.